second and final instalment of Sir Brian Leveson's review on how to tackle the court crisis has been released this morning. There are dozens of recommendations, including calls for more remote hearings and even greater use of technology and AI. I'm pleased to say that Sir Brian joins me now. A very good morning to you, Sir Brian. Thanks so much for joining us.
Good morning.
How bad is the situation in the justice system? Set it up for us.
It's very serious. So the backlog is now nearly 80,000 cases, double that which it was in, I think, 2016. It means that trials are now being listed for hearing in some courts as far away as 2029 and 2030. And that's, in my mind, a denial of justice for victims, for witnesses, and indeed for defendants, all of whom need to be able to move on with their lives.
Today you're releasing phase 2, a long list of recommendations, particularly focused on driving efficiencies, and I want to get to that in just a moment. But first I wanted to reflect on your op-ed from the weekend and some of the key takeaways from phase 1 that's caused a lot of debate in recent months. The headline being, just sum it up for us, you do think we need to remove jury trials in some instances?
Let me put it the other way around. Let me say we need to focus our resources on the most serious trials and the most serious allegations of crime. What I've recommended is that the threshold is adjusted. That's happened many times in the past. So, yes, I do believe that there are some lesser offences that presently attract trial by jury which should no longer attract trial by jury, because we need to focus on the more serious trials to get them through the system at a faster pace than is presently happening.
You wrote this weekend in an op-ed, I believe some critics of this recommendation are choosing tradition over a sustainable system for victims and defendants. Surely the criticism is not about tradition, it's about principle.
I've been focused on the principle throughout. I've practiced the criminal law for over 50 years, and I have a great respect for the systems that we've had in place. But the first principle must be that trials are conducted within a reasonable time. At the moment, I've told you, they're listing cases many years in the future. The result is that victims who want to move on with their lives are withdrawing their complaints, and that's not justice at all. That's a denial of justice. So I am in entire agreement with those who say, well, we've had a wonderful system, we should maintain it to such extent as we can, but this isn't a binary issue. It isn't possible to carry on with the approach we have adopted to criminal justice over the years in the light of the present crisis. And let me make it clear, that crisis has been caused in some parts for understandable reasons. First of all, the complexity of the criminal law has increased. Secondly, the complexity of the evidence. Let's think about that. Mobile phones, which now produce our communications data, available in most cases that are prosecuted, weren't in existence 20 years ago. Data it overwhelms police investigations and thus trials. This is all more evidence that has to be adduced. On top of that, we've introduced all sorts of protections within the system. PACE, the Police and Criminal Evidence Act, the disclosure of unused material, the protections for vulnerable witnesses, the protections for defendants, intermediaries, interpreters. All these measures have served to double the length of time that serious crime takes to try.
I guess some would say that the debate is not therefore principle versus tradition, but prioritising of principles. But your answer is still very clear. Just a final question on this point before we get to phase two. Clearly, there was a lot of coverage when a leaked memo came from the Justice Secretary about how he saw the best way to implement your recommendations. And there was a difference from your phase one recommendations. And without oversimplifying it, I think it's fair to say he was proposing removing juries from cases where it might lead to a punishment of less than 5 years. Yours had been for only less than 3 years. And for many of these changes, you'd proposed a judge plus 2 magistrates rather than a jury, and he wasn't including those extra 2 magistrates. He seemingly has stepped back from some of those proposals at this stage. Would they have been a mistake? Would they have been too much of a change?
Well, I certainly took the view that 5 years was too much, because what I'm trying to do, as I've said, is adjust the threshold, as we have in the past. So breathalyzers used to get you a trial by jury. Criminal damage less than what's now £5,000 used to get you a trial by jury. Now it doesn't. Taking a vehicle without consent used to have a trial by jury. Now it doesn't. So I was suggesting moving the threshold with it, which justified a trial, entitled you to trial by jury. The Justice Secretary clearly has now taken that 3-year threshold. What was leaked and what was contained within the leak, I'm sorry, that's not my neck of the woods.
Fair enough. Part two today, you're addressing inefficiency more broadly. Are there any easy wins?
Well, there are some comparatively straightforward things that can be done, but the real problem with the system is that it isn't a system. It's a series of systems. So the police have their own financial priorities and their own operational priorities. The CPS have their own priorities, the courts theirs, the defence community theirs. Nobody joins them together, and therefore to try to arrange that everybody is working in a coordinated fashion is the first challenge. There are some easier wins. The way in which files are put together by the police for the CPS for charging decisions to be made, I think can be solved quite quickly. The whole business of redaction ought to be capable of solution with the use of AI, not to make decisions, but to ease the process. There are lots of things that can be done.
So sum it all up for us, Sir Brian. Are you confident that in 5 years the government will make changes that will solve the crisis we face?
If you read a footnote in part 1, you would have said, I can't guarantee that this is going to solve the problem. What I can guarantee is that if we don't do everything we can, we certainly won't solve the problem. We've just got to pull all the levers. That's money, it's structural reform, and its efficiency, all three, to try to get us out of the spiral. Because if we don't get out of the spiral, it will just get worse. When I reported in July last year, there's a graph which identified how many cases were going to be in the system. We've already exceeded the upper limit of that graph by now.
Are you confident that the government will pull those levers successfully? Will they deliver?
I hope so. The government has to deal with the legislative process if they're going to take those steps, and they have to deal with the complications surrounding getting everybody to work together. So I hope so. And I have no doubt there is an enthusiasm in government to do it.
Sir Brian, thanks so much for stopping by. We appreciate it.
You're very welcome.